Kansas has a landlord-friendly tenant screening environment with minimal state-level regulation beyond the federal baseline. The governing framework includes the Kansas Residential Landlord and Tenant Act, found in Kansas Statutes Chapter 58, Article 25, along with FCRA and the Kansas Act Against Discrimination. Kansas gives landlords broad discretion in the screening process, consistent with the state's overall property rights orientation and market-based approach. Let's start with application fees. Kansas does not cap application fees. There is no state statute limiting what a landlord can charge for tenant screening. The Kansas Residential Landlord and Tenant Act does not address application fee amounts, procedures, or refund requirements. Landlords can charge whatever they determine is reasonable. Most Kansas landlords charge between $20 and $40 per applicant. Kansas's rental market is generally affordable, and keeping fees proportionate to actual screening costs is good practice. In competitive markets like the Kansas City suburbs and Lawrence, applicants are accustomed to paying standard screening fees. In smaller markets across the state, keeping fees modest ensures you don't discourage applicants in an already limited pool. Criminal history screening in Kansas is unrestricted at the state level. Kansas does not have a ban-the-box or fair chance housing law for housing. There are no state-level restrictions preventing landlords from asking about criminal history on the initial application. Landlords can inquire about arrests and convictions, can use criminal history as a screening factor without conducting a formal individualized assessment, and are not subject to state-mandated look-back period limits. No Kansas municipality has enacted a local criminal history screening restriction for housing. The Kansas side of the Kansas City Metro, including Overland Park, Olathe, Shawnee, and Lenexa, has not enacted local screening restrictions despite being adjacent to Kansas City, Missouri, which has enacted its own tenant protections. Wichita, Topeka, Lawrence, and Manhattan all operate under the same unrestricted framework. Kansas has a preemption statute, Section 12-16-1919, that limits the ability of local governments to regulate certain aspects of the landlord-tenant relationship. This preemption, combined with Kansas's conservative political environment, makes it unlikely that individual cities will enact local screening restrictions that deviate from the state's market-based approach. Kansas has provisions for expungement of certain criminal records under KSA 21-6614. Once a record is expunged under Kansas law, it is treated as if the conviction never occurred. The individual can legally state they have not been convicted. Landlords cannot consider expunged records in screening decisions. Screening providers should filter expunged records from reports, and landlords should verify their provider's compliance with Kansas's expungement statutes. Kansas has not legalized recreational marijuana. Possession remains a criminal offense. However, landlords should be aware that neighboring states, including Missouri and Colorado, have legalized recreational marijuana, and applicants relocating from those states may have marijuana-related records from jurisdictions where the conduct is now legal. The weight given to minor marijuana records in screening decisions should be evaluated thoughtfully in this border state context. HUD's 2016 guidance on criminal history and disparate impact applies in Kansas. While Kansas's demographics are less diverse than some states, the state's major cities, particularly Kansas City's Kansas suburbs, Wichita, and the military communities, have diverse populations. Criminal history policies that disproportionately affect minority applicants face scrutiny under federal fair housing law. Blanket rejection policies that cannot be justified by legitimate business necessity create federal risk. Documenting your criteria and applying them consistently is the smart approach. Source of income protection does not exist at the state level in Kansas. Landlords are not prohibited from considering the source of an applicant's income when making screening decisions. Landlords can legally decline applicants who pay with housing choice vouchers, Social Security, disability payments, or other government assistance. No Kansas municipality has enacted a local source of income protection ordinance. Participation in voucher programs is entirely voluntary. This is notable for landlords in the Kansas City Metro. Properties on the Missouri side in Kansas City, Missouri may be subject to that city's source of income protections, while properties on the Kansas side in Overland Park or Olathe are not. Landlords operating on both sides of the state line need to understand which rules apply to each property. For credit reports, Kansas follows standard FCRA requirements, permissible purpose, written consent, and adverse action notice procedures. Kansas does not impose additional state-level requirements for credit report access, adverse action content, or notification timelines beyond FCRA. Kansas's fair housing protections under the Kansas Act Against Discrimination, found in KSA Chapter 44, Article 10, prohibit discrimination in housing based on race, color, religion, national origin, sex, disability, familial status, and ancestry. The inclusion of ancestry goes slightly beyond the federal baseline, providing broader coverage for individuals of specific ethnic heritage. Kansas has not added sexual orientation, gender identity, marital status, age, or source of income as protected categories at the state level. The Kansas Human Rights Commission investigates fair housing complaints and has enforcement authority. While the state law doesn't protect sexual orientation or gender identity, several Kansas cities have enacted local non-discrimination ordinances with broader protections. Lawrence enacted one of the earliest local non-discrimination ordinances in Kansas, protecting sexual orientation and gender identity. Roland Park in the Kansas City Metro also has local protections. Landlords in these cities must comply with the broader local requirements. Kansas has a strong anti-retaliation provision under Section 582572 that creates a 6-month rebuttable presumption of retaliation if a landlord takes adverse action after a tenant exercises a legal right. While this primarily applies to existing tenancies rather than the screening process, it reflects Kansas's commitment to protecting tenants who exercise their rights, and landlords who screen out applicants based on a history of filing complaints or exercising rights at prior tenancies face risk. From a practical standpoint, Kansas's rental market is concentrated in a few population centers, with the rest of the state having more limited rental activity. The Kansas City Metro, specifically the Kansas side, including Overland Park, Olathe, Shawnee, Lenexa, Leawood, and Prairie Village, has the state's strongest and most competitive rental market. Johnson County is one of the wealthiest counties in the Midwest, with a strong economy driven by corporate offices. Sprint's former headquarters, now T-Mobile, is in Overland Park. Healthcare, financial services, technology, and professional services. The applicant pool in Johnson County tends to be well qualified with strong credit and income profiles. Rents are the highest in the state, and the market supports thorough screening standards. Wyandotte County, including Kansas City, Kansas, has a more affordable and diverse market. The economy is driven by the Kansas Speedway Entertainment District, logistics, manufacturing, and healthcare. The University of Kansas Medical Center is located in KCK. The applicant pool is more diverse than Johnson County, and landlords should ensure their screening criteria are documented and consistently applied. Landlords operating across the Kansas City Metro need to understand the state line distinction. Properties in Kansas are subject to Kansas law. No source of income protection, no local criminal history restrictions, state-level preemption of local regulation. Properties across the state line in Kansas City, Missouri are subject to Missouri law and Kansas City, Missouri's local ordinances, including criminal history restrictions and source of income protections. This distinction matters enormously for landlords with properties on both sides. Wichita, the state's largest city, has a moderate rental market driven by aerospace and aviation, including Spirit Aerosystems, Textron Aviation, and Bombardier Learjet, healthcare, manufacturing, and Koch Industries headquarters. Wichita has a diverse and growing population, including significant Hispanic, Vietnamese, and African refugee communities. Screening applicants from diverse backgrounds requires consistent criteria that evaluate ability to pay and tenancy reliability without bias. McConnell Air Force Base in Wichita generates military rental demand. Military tenants provide reliable and verifiable income, and landlords should understand military income documentation, leave and earnings statements, and BAH rates. Wichita's BAH rates are modest. Topeka, the state capital, has a stable market driven by state government, healthcare, including Stormont Vale Health, and education. The market is affordable with moderate demand. Lawrence, home to the University of Kansas, has one of the tightest rental markets in the state relative to its size. KU's large enrollment creates massive student demand and seasonal turnover. Lawrence's progressive political environment and local non-discrimination ordinance make it the most tenant-protective city in Kansas. Screening students with limited credit and rental history is routine. A consistent cosigner or guarantor policy is essential. Manhattan, home to Kansas State University and adjacent to Fort Riley, has a unique market driven by both the university and the military. Fort Riley, home of the 1st Infantry Division, is one of the largest Army installations in the country and generates enormous rental demand. Military tenants represent a huge portion of Manhattan's rental market, and the intersection of student and military demand creates a dynamic market. Landlords in Manhattan need dual competencies: screening student applicants with limited histories and screening military applicants with standardized but unique income documentation. Fort Riley's BAH rates are moderate and directly drive pricing. The deployment cycle creates regular turnover as units rotate in and out. Having streamlined processes for both applicant types is essential. Fort Leavenworth, home to the U.S. Army Command and General Staff College, generates military rental demand in the Leavenworth and Lansing area. The officers attending the Staff College are typically majors and lieutenant colonels with excellent credit and income, representing some of the most desirable tenants in the market. However, their assignments are typically 1 year, creating annual turnover that landlords near Fort Leavenworth should anticipate. Salina, Hutchinson, Emporia, Dodge City, Garden City, and Liberal have smaller markets with varying demand levels. The western Kansas communities of Dodge City, Garden City, and Liberal have rental markets significantly influenced by the meatpacking industry. These communities have diverse tenant populations, including large Hispanic and immigrant communities, drawn by employment at major meatpacking facilities operated by Tyson Foods, Cargill, National Beef, and others. Screening workers in the meatpacking industry involves verifying employment income from an industry with relatively high turnover. Having a clear and consistent approach to evaluating these applicants ensures fair treatment. Hays, home to Fort Hays State University, and Pittsburgh, home to Pittsburgh State University, have small student-influenced markets. One best practice for Kansas landlords, even though the state imposes virtually no screening restrictions and preempts most local regulation, develop a written screening policy that documents every criterion you apply. Your policy should specify credit score thresholds, income-to-rent ratios, rental history requirements, criminal history evaluation standards, and how you handle applicants with limited credit files. Apply those criteria to every applicant uniformly. The absence of state regulation doesn't eliminate federal fair housing obligations. Documented, consistent criteria are your defense. Another best practice: for landlords in the Kansas City metro, understand and maintain the distinction between Kansas side and Missouri side regulatory requirements. Don't apply Missouri side restrictions to Kansas side properties unnecessarily, but also don't apply Kansas's permissive framework to Missouri side properties. If you own properties on both sides of the state line, maintain separate compliance procedures for each state. A third best practice: for landlords near Fort Riley, Fort Leavenworth, and McConnell AFB, develop a standardized military screening process. Military income is the most verifiable and predictable income you'll encounter. The LES shows exact pay, BAH is guaranteed, and employment stability is generally excellent. Having a military screening checklist that your team follows for every military applicant streamlines the process and ensures consistent treatment. Understand the typical assignment lengths: 1 year at Fort Leavenworth, 2 to 3 years at Fort Riley, and plan for the corresponding turnover. Kansas limits the security deposit to 1 month's rent for unfurnished units and 1.5 months' rent for furnished units. The deposit must be returned within 30 days of the tenant vacating, along with an itemized statement of deductions. If the landlord fails to comply, they may be liable for 1.5 times the amount wrongfully withheld. The limited deposit cap makes thorough screening your most important financial protection. Getting the tenant selection right is far more cost-effective than relying on a 1-month deposit to cover potential losses. For the complete guide to Kansas tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.